Jadhavar Group of Institutes has recently started Jadhavar Law College. Principal of the college is Mrs. Dev, an eminent jurist and the one who is thinking always that how the society will get good law graduates coupled with ethics and energy to serve the society in legal field. With this, I congratulate them to have a YouTube channel so that the thoughts which I have developed for myself and for my colleagues at the bar doing practice for 53 years will go to the students and to the legal fraternity. Now let us take the topic ethics and responsibilities of bar and bench. As it can be seen that we have got 3 years law course and 5-year law course. Initially, prior to 1969, there was 2 years law course with bar council exam. Then since 1968-69, the bar council introduced 3 years law course and dropped the bar council's exam. Once you pass 3 years law course, you are immediately entitled to enroll yourself as an advocate with the Bar Council of Maharashtra and Goa or any other respective state bar council. And you were getting sanad, which they are calling it, to practice in the courts. To that extent, it was all right. But then the questions comes that a law graduates with sanad to practice come in the court. And what is his positions? That is to be seen. When I joined the bar in 1972, Pune bar strength was only 250 advocates. And even at that time, we were told that there is already a rush number of advocates and what more you are going to do. But ultimately, when you have decided to enter into the professions, you find your way depending upon the valuable time you give, the energy you possess, the qualifications, and coupled with sacrifice of your other rituals, or we can say that the other practices, family, company, and all other habits are concerned. So the questions comes that how you get yourself an advocate which will be accepted by the society and they will consider you as and when there are legal problems. Let me tell you, the first part of it is when we were in the law college, it was told to us that while going in a court, you must be properly dressed. Properly dressed means the prescribed by the bar council and with a reasonable your all appearance while going to the court, coming out of the court, and even remaining in bar room. I will again say that the background of the advocates, it starts from the first year of law, because one has to develop the habits that I want to become a good lawyer. The question comes that a student takes admission in the law college. Majority of them have intentions to practice. Few of them have intentions to have qualifications which may help them in their service career or in various other fields. They may join politics or they may do other parts. But then habit as an advocate, it starts that the college starts grooming them from the beginning. Or I will say that college should groom them from the beginning. What it means? That when you go to the classroom, you must be fully prepared yourself for the lessons which the professor is going to teach. The difference between the legal study, which is called again as a technical one or professional one, and the other graduation courses is quite a different one. When you join the professional course, you must understand that you are joining a professions which has a credentials to serve the society. Of course, monetary part is always there, but the main intention is to serve the society. And to serve the society will full commitments. My friends, we must keep it in mind that when we join the legal professions, our client gives their entire fortune, entire subject in our hand, which may take them to hell or heaven. We have taken the responsibility as an advocate, and so it is our responsibility to be truthful, faithful, and work with all sorts of details working it. So again we come to the first year part. If the students have developed the habit of reading the books, textbooks, understand it, and in particular try to have a good conversations with the professors and students, then it will continue after he completes the legal educations or law. So the questions will be that the first part to observe will be that you must develop the habit of reading and understanding the entire subject. As it can be seen that what will be your second part? Means always in advocacy, there is a practice to have a cooperations, conversations, and graceful dialogue with your colleagues and with the courts where you represent your client. It is said that your behavior in the court must be assertive, but not with arrogance. And that part you develop from your first day of the law college, entering there. Because ultimately, indifferent attitude towards the professors, indifferent attitudes towards attendance, indifferent attitudes towards reading, that is not a good habits or ethics. And therefore, I always say that don't be a law graduates with 3 weeks course for 3 years law students and 5 weeks course for 5 years law students. Because generally it has been found that the law students feel that the first 3 months, 4 months are concerned. In our time, there were not terminal examinations, but it was the yearly examinations. Now they have introduced the terms, and accordingly first term, second term, 6 terms or 10 terms. So then the questions come that one has to understand that the entire subject is connected with each other, and there should not be a place for keeping any subject in option. What happens that in the beginning, having a discussions among the students, you enjoy more in a company of students outside the class or in various other activities than in the legal studies. I always advise, and which I was following. I was the students of Indian Law Society, the ILS Law College. As and when I used to find time, I used to sit in library. In library, the books, theoretical books and main books on the subjects are concerned, they are in many. We have to read on each topic and thereafter understand the subject. You see, the study of law is one that you study with the view of getting the marks, good marks in university exam, and that's all. And other is that you study with understanding the subjects and then getting good marks in exams. So if one will choose that study, understand the subjects, and then appear for exam, then that is a different part. So as we say that in these 3 years, what habit we have to develop? Read more and more, understand the subjects, and for the last 2 months, you can deploy for study from the point of view of getting more and more marks. So good conversations with the professors, with the students, developing good habits. Now here the questions comes that what can be good habits? I will ask myself that only because I am an early riser. before the sunrise. So everybody must be of that kind. That cannot happen because it happens from time to time. But I will say that if you are managing or planning your day to give time to everything, you may have some time to play on the ground, you may have some time for the family, you may have some time for entertainment activities, but you should have a sufficient time to read the law. Now the next part comes, as I have said, that always, whether as a student or as a lawyer, you should be well dressed and not to be in objectionable forms which can be there. Let me tell you that I am proud to say that those lawyers who had come from my chambers, who have interned with me, even if they have completed and started their independent practice 20 years, 30 years back, still they are taking care that whenever they come in the courts, they have a white shirt. And with one part that they have understood the responsibility. Why we should be well dressed as prescribed in the Bar Council? That it makes you responsible and separate than the normal persons when you are as an advocate. And therefore, you have to develop other part. Now the second part comes is when you enter into court, then how you have to enter, and even if the order is for or against, how you have to come out of the court hall. The third part comes that while working on the matter, you have to assist the court, but not to bluff the court. Because one understands that you read the case law. As I can say that head notes of the case laws are not always good. It is not that always they are faulty or defective, but majority of the times the head notes which are given in journals are prepared by some law students, and so they may not be the correct saying principle of law. So you have to read the case before citing it before the court. Second part, that even if you will try to avoid it, the courts, the presiding officers, they know the law, and therefore number of time opinion about you should not be that you are not properly assisting the court. So an advocate is supposed to properly assist the court, and court is supposed to properly give proper opportunity to the lawyers, what they say, to hear, listen, appreciate, and give the judgments. Ultimately, what is the ethics is that on the part of court, that they have to come on time, the advocate has to go on time, so you have to develop the time management and value of time. I can say that during the period of 72 to 80, the district judges along with their peon, they used to visit the entire court campus of Shivajinagar Court, and if any presiding officer had not been on the bench by 11 o'clock, notes were prepared, and during the lunch hours they were called by the district judge and they were given an understanding that you have to be at time. So that was a management or the control of the district judge upon the judicial officers. At the same time, it is the responsibility of the advocates to be in time, to be ready with the facts and figures, to be ready with your brief with all the documents, and to conduct the matter. Asking for adjournment does not give you a very good pictures. Asking for adjournment by giving false explanation is again, it is very bad. When it has been found that generally some of the practices that when the advocate doesn't want to continue with the matter or does not want to conduct the matter on that day, they give sick note, that is, he is not feeling well and he cannot attend the court. And when it is found that at that time only you were engaged in various other matters which were on record, then certainly not only it is a misconduct as per the Bar Council's rules, but it gives you a bad shape or bad image in the eye of the presiding judge. The topic of ethics of bar and bench is too vast. We can go on doing it, but in short, if at all we want to say that be prepared fully, go to the court with respect, give respect to the chair, that is the presiding officer, say entire things, represent your client's interest, don't compromise with your client's interest, And I will say that it is again the responsibility of honorable judges or presiding officers to discharge their duties without fear and favor. They have to give opportunity to each lawyer to present their case. They must have a habit of reading the matters and, if possible, to deliver the judgment immediately after hearing the matter. Generally, it has been found that the courts are taking months together for delivering judgment. So I think that courts are concerned, they are bound to be in the uniforms, there is no problem. But so far as the advocates are concerned, uniform with good habits and helping others, be ready with the books. I will give one small example and how bluff does not pay. In Karki, when I was practicing, there was one lawyer, I will not say name, say X. He was always in the habit of saying, Your Honor, in judgment so and so of AR 1967, on page number so and so, this is the principle laid down. The magistrate was knowing about things. So he used to say, Mr. So and so X, the judgment is overruled in the year dash dash with the judgment so and so. And the bar and bench used to laugh at it. So the question is that don't try to cite judgments either which are not there or making a wrong interpretations of the parts are concerned. So the questions will be that be faithful to your client. Then second part, don't promise the client false. False promise is concerned and getting the works will not only bring you in problem, but it will develop all sorts of ailment in your health also. Because when you give a false promises and when the client comes before you, you are always under pressures. And when you are under pressures, you develop various kind of the ailments. So the question is that you try to understand the case, tell the client what are the merits of it, and take up the matter. I am sure that at junior stage, you have to do this procedure tactfully. Because when the client will come to you and you will say that you have a bad case and you will lose, he will say that give me paper back, I will go to other advocate. For the senior advocates are concerned, even if he says that it is a bad case, the client will say that yes sir, but we have come to you, so use all your intelligence and give us the result. If not, also that is not there. But then what junior advocate should do? If he has prepared the entire matters by reading all the papers, then he can say that these are the plus point, these are the minus point, and I will try from this point of view, this will be there, I will make an effort. Clients normally keep faith in the advocates who give the straightforward advice. So the questions will be that from the day of the student's first day till you join the bar and thereafter remaining in the bar, you have to be very generous to the colleagues, faithful to the client, and respectful to the court, so that you will neither lose the court, neither lose the client, and you will not require to make compromise with your elements. Topic of present discussions is art of advocacy vis-a-vis cross-examinations. Let me tell you, it's a very wide subject. Art of cross-examination is the things which is an instrument to extract truth from the mouth of the witness, from the mind of the witness, either individually or collectively. And therefore, any advocate who has mastered the art of cross-examinations always have a good standing, and the success ratio is much more. Now, let me tell you that normally the advocate feels that cross-examinations means to deny what the witness has said in the beginning in examination in chief, or to read it and give some suggestions, or to read his statement and try to make out the case and stop the things there only. But that is not so. The cross-examination is an art means what? First, let us know in the Evidence Act, there is the provisions of examination in chief, thereafter cross-examinations, and thereafter re-examinations. So, cross-examination is to discredit the witness with the help of what he has stated in examination in chief and with his previous statement, earlier statements, circumstances on records, and the documents which are on record. We will make these propositions by way of an example. In a case when it was happened that there was a charge that husband has harassed, given cruel treatment to wife to have Honda from her parents. And it was said that husband and his family demanded 2 lakhs rupees, and therefore that resulted in the harassment and that particular part. But when the record was found and it was came on record that the father of the girl had obtained 5,000 rupees by way of a loan from the brother of the husband in the past. And in another matter, the brother of the husband was a surety for the father of the girl who took loan of 20,000 rupees from the bank. Now, with these two documents in mind, when the cross was developed and ultimately it was brought on record that if to the knowledge of the husband, his brother, his family, the financial positions was known, then why he will harass on that particular point is concerned. And that point during the course of the trial was collapsed and nothing was happening in that part. So that you must know not only the statement of a particular witness to whom you are cross-examining, but the statement of all witnesses who are going to be examined or who are then on record. So the cross-examination is concerned, you have to make out your mind ultimately what will be your defense or what case you want to develop. The cross-examination is in civil court and criminal courts and even before tribunals. But in the criminal courts are concerned, it is more relevant, and in the civil courts are concerned, more or less it is based on documents and other parts are concerned. So in the civil court is concerned, your expertise is to read the document, understand it, and go for cross-examinations here and there. But in the criminal courts are concerned, you have to be ready with the facts and other parts are concerned. Here, as I have said earlier in my other speech, or we can say that other podcast, that an advocate must read or understand sociology and psychology and philosophy. Because when you cross-examine a particular witness in the court hall, before the court, you must understand whether the person will be afraid of loud noise or will be more violent, whether he will give good replies by having a calm and quiet questions, whether he will be confronted with other records, whether he will be able to give you the correct admissions. And therefore, to become a good cross-examiner, you have to be equipped with all qualities which a good lawyer requires. At the same time, you have to, as I have said, that understand the subject for which the case is there. Because ultimately, any case is concerned, it is not in isolation only a legal case. It is coupled with finance, coupled with contract, coupled with engineering, coupled with medical and other parts are concerned. As it can be said that in the cross-examinations, to what extent you cross-examining is good, but you must develop the idea of where you have to stop. Because sometimes the cross-examination is a double-edged weapon. By developing one case and cross-examining other witness, you may destroy the first part where you have got the admissions and other parts are concerned. To give an example to that extent is concerned, that suppose that under the Essential Commodities Act, you developed a case that you were in the business of a retail one and you got the admissions from one witness, and in the other witness you ask the questions that even though you are a retail business, you have so many transactions of which will make you from the retail businesses to wholesale businesses. Then whatever the admissions you got from the first witness, it will be destroyed and you will face a difficulty in defending the case. There are a number of incidents where you have to control yourself while cross-examinations. And therefore, I sometimes say that gum khana is one of the part, or gupchup rahna is another part, or to stop yourself after getting admissions is another part. Advocates are concerned, they feel that more and more cross-examinations is there to play with the gallery. But then it brings you to a positions where it damages your client's case. And therefore, when we say that how to cross-examining, if you have got best part of defense you have in your mind, then it helps you for cross-examinations. The next part it comes that in the cross-examinations, you have to see the mind of the judge, the mind of the witness, and mind of the other side. You have to create an atmosphere with your own behavior, that to what extent you can go, to what extent the witness will give reply. Now, so far as the cross-examinations on the medical point of view, when there is a doctor and to whom you have to cross-examine, don't try to be over smart because doctor knows everything. And they're putting a questions which you have no other data to disprove it or to destroy whatever the admissions he is giving in cross-examinations. It may damage your case. So the questions will be that when you are cross-examining the doctor, you have to be fully equipped with the medical jurisprudence relevant topics are concerned. As it can be said that what kind of the instrument was used, and while cross-examining, sharp cutting weapons, and thereafter you can say that you make another cross, because if doctor said that these 3 injuries were there, which were as a result of sharp and cutting weapons. But to prove that doctor is making a false statement, if we say that there were bullet injuries, which was not he has told in the earlier part, and if you find that that is there, then whatever has not come in examination in chief, you try to bring it in the cross-examinations. So your cross-examinations should be restricted to what he has said in examination in chief and what other witnesses are likely to say in examination in chief. Here we can say that suppose the doctor has said that the age of injury is 2 days or 48 hours. And from the record it can be said that the incident has occurred 4 days before. Then automatically the doctor will be discredited or the entire case of the prosecution will be discredited. So you have to keep it in mind. Then there questions comes that how to prove, and if there are latches in the examination in chief, don't try to fill it by cross-examinations. So restrict cross-examinations, or I will say that tendency of going on asking questions is not a good cross-examinations. So the questions is that you have to keep it in mind when there is a case of what kind of the case you are defending. Again, I will say that the cross-examination is concerned, it depends from person to person on the same point. A person coming from village background, the tendency of telling truth is always there. And therefore, you should put cross-examination, control yourself to put the questions only on the basis of record and not what is happening in the village, because you have no idea how to destroy the admissions, whatever he will give in the cross-examinations and other parts are concerned. Now the other part comes in the cross-examinations, that how you have made your homework of the entire case. You have to see the background of the persons with the help of the previous record also. Nowadays it will find a number of places that the panchas are concerned in various cases, you will find that they are habitual panchas. How you will find these habitual panchas? So that part is concerned with the help of the record, you can find that the same persons was a punch in number of cases, more than 5 or 10 cases. And if you bring this on record that he is a habitual punch, then he can be discredited. Another part is that you have to read all the papers minutely, which will help you. That suppose that at the end of the Panchnama it has been said that it was carried out between 8 to 10 p.m. And if we are able to establish that there was darkness and there was no reason to see all these things are concerned, then leave the thing as it is and bring it with the help of other witness that during that period there was no light and nothing can be seen. I will give you one more example that you must understand how it can be done. In 2 or 3 cases continuously, one sub-inspector, he was investigating case of murder and other parts are concerned, while discovery panchanama, in all the 3 cases, when either the knife was used or other thing was used, the discovery panchanama was made that at the bank of the river, between the 2 stones, the knife was hidden, and the accused has shown that in the presence of 2 panchas. When it was found that in all the cases he has followed the same things with the same panchas, this evidence was discarded. So you have to understand, keep the records of everything properly. Then the questions comes that you must know the provisions of law while cross-examining. What is meant by conscious possessions? What are the authorities of the officers while having a search and seizure? What are the authorities of the persons? Let me give an example. In the beginning of my career only, number of robberies taken place in Pune, and gold jewelries from the house of various persons was stolen. The accused in that case was in a habit to stay in one of the guest house in Pune, have a robbery during the night time, go in the morning's train to Bombay, sell it in one of the shopkeepers and come back. Again he will do it. Then during the course of trial it was found that the ingots of silver and golds were produced, or the gold ornaments were produced. But when it was found that the ornaments which were stolen were gold, and the ornaments which were before the courts were of the silver with plated golds, it may be a dishonesty of the businessman who produced it. But then a questions was asked in the cross-examinations to the complainant who was owner, that how you are identifying these bangles. So she said that I am always wearing this, and so I have identified it. The gold and civil parts are concerned, it was already a cross-examination, it has common record. But these questions, that how you identified that it is your own bangle, it was no need to ask. When it was said that it was gold bangle and before the court it was civil. But the admissions given by her, that because I was using the bangles, so I can identify this is my bangle, that has destroyed the case of the defense. So the questions comes that how and how to do the cross-examinations. When it comes with respect to the accounts, when it comes with respect to the buildings, collapse of buildings, other parts are concerned, then you must know that how the manufacturing of cement taken place, what is the quality of the cement, what is the things which made the building to collapse, what were the factors which have come into existence. So you have to consider that when I am cross-examining, first of all, my defense that it is not a case of negligence. And when you say that it is not a case of negligence, you have to make out a case that the concerned person has taken all the precautions by purchasing ISM mark articles with the help of the experts, that is RCC consultant and architect. All the steps were taken, and in spite of it, there is a collapse. Then the benefits of reasonable taking precautions will be given. So whether it is a case of the environment law, criminal cases, or other parts are concerned, you must have adequate knowledge of that subject. Then so far as the attempts are concerned, you should make an effort that there will be a trial day to day. And the witnesses are concerned, when there are a number of eyewitnesses, request can be made to the court that they should be examined one after other. So no chance of parting on the cross-examinations and other parts are concerned. Let me tell you one example. I was conducting a trial of well-known social workers, and there were 5-6 witnesses were there. So the advocate said that, sir, I have brought only one witness today. I said, why? To bole, what cross-examination you are going to do? I will prepare my second witness, and so that your cross-examination will not be effective. I told him that, do you think that I am going to cross-examine the witness in the similar way what I have done to first witness? You are under wrong assumptions. So your cross-examination should not be stereotyped. At the same time, your cross-examination should be to the facts, to the law, and when your cross-examination is taking into consideration the facts and law, it will always be effective cross-examinations. You have to be kind to the witness sometime. You have to be graceful to the witness. You have to not to challenge in unnecessary way. And you must know, putting the questions, that to what extent you are master of that subject. If you are not master of subject, you have to leave the things as it is. So I will say that understand the psychology of the witness, have a philosophical attitude, social attitude, and after preparing yourself with the facts and law, go to the cross-examinations. And with other quality of advocacy, you can certainly give good result to the client, and you can use effectively the weapon of cross-examinations to extract the truth from the witnesses.